Manhattan Neighborhood Network's Race to Represent, in partnership with the League of Women Voters of New York, are pleased to bring an interview with the New York County District Attorney. Hi, I'm Paul Schindler, founding editor-in-chief and associate publisher of Gay City News and Manhattan Express. The Manhattan District Attorney is the elected attorney representing New York County. The office is responsible for the prosecution of violations of New York state law here in Manhattan. Cyrus Vance has held the office since 2010, and he is seeking re-election to a third four-year term this November. He is running unopposed in next week's primary and in the November general election. Mr. Vance, welcome, and thank you for joining us.
Hello, Paul.
The New York Times yesterday had a major story about questions that have been raised about a procedure used in the city medical examiner's office that basically allowed samples of DNA which were smaller than would normally have been acceptable for use in criminal prosecutions to be analyzed and used. The story dealt with several controversial cases in the Bronx and Brooklyn, did not specifically address anything in Manhattan. But are you confident in that testing method?
Paul, as I understand the technical issue, and I'm not a DNA expert, but clearly rely heavily on DNA analysis, so it is a significant part of our ability to both identify those who committed crime and exonerate those who did not. So I have a very strong interest in this in both senses. As I understood the article, it is not that DNA is itself not an incredibly valuable tool still, but it is an analysis of sort of advances in DNA and problems with those advances. So I think first and foremost, it is not that the DNA is not analysis is being done competently and correctly by the medical examiner's office. I don't think we should throw things out if they provide us with further information. Obviously, we don't want misinformation. So what I looked for now is an analysis by the experts in my office, of whom we have several, to advise us on whether there are any cases that they feel are implicated by any problems with low copy DNA and the like. And I have not yet received any information that cases in our office are going to be affected negatively. But overall, to answer your question, big picture, in our business, it's important that we move forward with scientific advances. We can't fall in love with science, but we have to acknowledge that as science moves us forward, we need to use it and then analyze it. Here, there are questions about low copy DNA. They can't be ignored. But I'm not yet aware of those test results affecting our cases negatively. But we need obviously to be very careful.
Yeah, and to be clear, the Times story did not say that there was any definitive judgment that those tests were wrong. It rather spoke to the controversy. One interesting point in that article, though, was that there were a number of defendants who, confronted with the information that there was DNA evidence, had pled guilty, and that those convicted would likely not have grounds for appeal. Would your office be open to allowing an appeal in a case like that if you believed that the testing had been flawed? Well,
if we believe the testing had been flawed, that would be something we would need to disclose to the defense if it was a case where charges have been brought.
Right.
So we have a conviction integrity unit, which I started in 2010. One of the first things I did when we came in there. And we invite inquiry by individuals accused to re-examine their cases. We don't re-examine all of them. We have to have some kind of basis as to whether or not it appears that there's some fundamental problem that bears further examination. But we are not afraid to, nor should we deny testing for DNA if there's a basis to believe that the testing is flawed. The bigger question is one of when do you provide this information? And if we found, Paul, that someone pleaded guilty, and subsequently we were to learn that a DNA test run exculpated that person. We provide that. My instructions to the office and my expectation would be that would not be something that we slid aside. That would be something that would be brought back. We'd have to analyze it. We'd have to alert counsel and the defendant and see where it took us.
And that conviction integrity effort has been ongoing throughout your tenure.
Yeah, we really, I think, were the first office outside of Dallas, Texas. Craig Watchin, an African-American DA in I believe it was Dallas, opened 1 year ago. They focused exclusively on DNA exonerations. In other words, where DNA could definitively say innocent, not or guilty. And we opened a unit not only focusing on DNA, but really the more difficult question of review of cases where no DNA evidence was dispositive, but I think even more importantly, focusing on what I will call the front end of the system, which is training of the office and the assistants in those areas where evidence has shown errors have been made in prosecutors' offices. So it's not just DNA, it's photographic identifications and lineups, taking of confessions and the like. And in each of these areas, we are providing specialized training so that the young men and women, many of them young men and women who are starting out, are doing the best analysis on the front end.
Last month, your office announced that you were dismissing 240,000 summons cases that were more than 10 years old. Right. And as part of that announcement, you also said that going forward, low-level offenses like fare beating would be treated as summonses rather than arrestable offenses.
We hoped, yeah.
Can you explain how that works for a young person who's caught fare beating? Specifically
fare beating?
Yeah, for example.
All right, well, as a background, just so your viewers understand how we got here, we have been systematically trying to identify low-level offenses that we believe should be handled outside of arrest and typical criminal justice process. And since 2012, about 25% of our caseload has been pulled out of the office, and those are low-level offenses such as pettit larceny for a first arrest offender and the like. We decided going forward that we really also wanted to take a close look at fare beating or theft of service. And so the police have a number of ways where they see someone who is evading fare. They can issue that person a transit summons, they can issue that person a criminal summons, and that is what the PD does on a number of cases. But about 10,000 cases a year in Manhattan, the police make arrests, and that means cuffs on through the system. But even in that 10,000 cases, the overwhelming number of individuals do not have prior criminal records or prior felony convictions, but for reasons that vary, some of them procedural, some of them probably interpersonal, the men and women are arrested and processed through the system. And it is that 10,000 cases is the area where we are focusing on our change in policy on fare beating. It is our belief that, and is our intent, and we issued a memo to all the office yesterday explaining it, that for that 10,000 cases, we are going to work with the police to try to have, if the individuals meet certain criteria, for example, no prior violent felony conviction, no open warrants, for example, then to offer that person diversion. That is, the police will stop them if they jump the turnstile. The police will have a right to pat them down. But the police, we expect, will also give them the option, rather than arrest, if they meet criteria, to do a diversion process. If the police, and if they do that, we will then work with a defense lawyer to have that community service option fulfilled. That's how we handled it for the 25% of the cases that I talked about. If the individual is arrested by the police, then we will examine that case once we receive it, and it doesn't mean that we won't provide diversion, but it will mean that of all these 10,000 cases, we will work to reduce that number significantly to have only the fewest live arrests as are necessary, and that's because I think fare beating is something that just needs to be looked at. I understand in the 1980s when crime was rampant, law enforcement was looking for every option to try to identify offenders and manage a crime crisis. We aren't there today anymore, thankfully, and I think we can use what Bill Bratton has called a peace dividend to be more thoughtful, to have more proportionate responses. If I drive 70 miles an hour down the West Side Highway, I'm going to get a ticket. If I jump over a turnstile, I don't think it's proportionate that I have handcuffs put on me and I'm arrested. It's trying to find proportionality, and that's our goal.
Is that the approach that's applied with small amounts of marijuana in public view?
I went to Albany probably 5 years ago and asked them to decriminalize marijuana at low levels. And I was joined by the governor, Commissioner Kelly, and several other district attorneys, and the legislature did not act. As a result of that, our office and others went to the PD, and we got the PD to change its policies so that the PD would not arrest individuals who had marijuana in their possession, but only who had it in plain view and smoking it. So the overwhelming number of marijuana arrests have been are now processed as non-criminal offenses or adjourned in contemplation of dismissal. But Paul, I really believe we can go further in this area, and my hope is that as we look at other states like Colorado, like Washington State, like California, I think our state's going to come to the point where it's going to have to make the decision: are we going to legalize marijuana or not? I think we're getting there. I think we need to study it, and then I think we need to make a rational, again, proportionate decision based upon the experiences of the states who have undertaken this change of policy.
Arrests are actually up for marijuana in the city. There were above 16,000 in 2016. A Queens College sociologist estimated that 85% of those arrests were people of color. Mm-hmm. Is this a stop and frisk sort of problem that needs more scrutiny?
Whenever we have disproportionate racial impact, we should be looking very carefully to make sure that how is this happening? After I was elected, I brought in the Vera Institute of Justice, the criminal justice think tank here in New York City, to come into my office and do a racial bias analysis of our charging and plea bargaining practices. And we found some disparity. And where we found that disparity, we have now radically rechanged both our practices in certain bail and charging practices, but more importantly, our approach, which is really moving away to not taking in low-level offenses, but pushing them to diversion. So we all should be looking at who is in our courthouse. One of the things that was both disturbing to me, but also very educating, is 30 years ago when I was a young assistant DA, I would be working midnight arraignments, and we all have sort of a memory of what it was like back then. But you couldn't help but be struck that everybody in the courtroom, who's charged with a crime, 95% of them were men and women of color. Mm-hmm. 35 years later, I come back to the DA's office to be the DA. You go down to court, it's the same ratio, which is one of the motivating factors that led me to bring in Vera to help us try to change that picture and try to acknowledge we have a problem and an issue with race in our justice system that we have to take on. Our office is taking it on by radically rethinking who we should bring into the criminal justice system in the first place, and where we have a significantly disparate number of men and women of color who are being arrested versus Caucasians. Yes, we have to take a look at that. We have to figure out why is that happening and whether it's appropriate, and try to change what policy is not working.
We're running short on time, but I did want to ask you about the decision early this year not to pursue charges in the investigation of Mayor de Blasio's contributions to state Senate campaigns in 2014. When Jim Comey last June announced he was not going to bring charges against Hillary Clinton in the email server case, he did make a series of fairly disparaging comments about her conduct in that situation, and that raised eyebrows. Mm-hmm. When you made your announcement, you called the mayor's actions an end run around campaign contribution limits. Mm-hmm. You said that your action was not an endorsement of his conduct, and you said that the contributions, quote, appear contrary to the intent and spirit of the laws that impose candidate contribution limits, laws which are meant to prevent corruption and the appearance of corruption in the campaign financing process. Can you explain what motivated you to make those comments at a time when you were announcing you were not charging? Sure,
absolutely. We live in a different world than we did 30 years ago. I think we are obligated to be more transparent today than we probably felt we needed to be 30 years ago. There was a lengthy investigation which was prompted by a very public referral to our office, a public referral that was leaked. with very specific criticisms levied and sort of conclusions levied against a number of individuals and entities. We conducted a lengthy investigation. We concluded ultimately that the conduct was ill-advised but guided by a lawyer, and that therefore criminal charges were not appropriate. But it was also clear that there were huge amounts of dollars going into upstate races, into campaign chests that never had a contribution more than $5,000 in the past, when $600,000 or $300,000 was coming through that process, which would not have been legal had it been a direct contribution, but using an intermediary. It eliminated the restrictions, the flat-out restrictions of the campaign law. So I think that the facts required elaboration, and the volume of money that was moved required some comment by our office as to our conclusions about the matter, which is what we did.
So transparency overrode what had been perhaps a convention in the past about the way prosecutors might handle something like that?
Well, first of all, prosecutors do things differently all over the time, all over the country. And I felt our letter was comprehensive. It was very factual. And we needed to explain why we did what we did, how we concluded, and why we didn't move forward. And that was the intent of the letter, and I think it laid it out clearly. And some folks found it controversial, and other folks thought it was exactly what should be done.
We have time for one more question. Your office's work on combating international banks that are violating international sanctions established by the federal government has yielded a fund of somewhere in the neighborhood of $800 million. I'm assuming that's the current number. It hasn't gone higher than that. Out of that money, you allocated about $38 million for jurisdictions that cannot afford to pay for testing of rape kits. Can you talk about the significance of that allocation and how you decided that that was a good way to use a portion of that money?
How much time do we have?
The time you need.
Paul, I think one of the saddest chapters that I've come to be aware of in my time as DA is that systematically all around America, men and women, victims of sexual assault, have tried to aid law enforcement by, after the assault, going to the hospital or some other location to be examined by medical professionals and to have the evidence of the sexual assault taken from their body in a very invasive, emotionally charged kind of examination, and to have that evidence set aside, the goal of which is to put the evidence in a rape kit, take that biological evidence, and to have it examined to see if a DNA profile can be extracted. And if one is extracted, to then upload it, the digital identification, to compare it with the digital identifications of known offenders in the national database. And it turns out there are hundreds of thousands of cases in which men and women have undergone this examination, but law enforcement, for whatever reason, either didn't have the money or didn't care, didn't actually test the kits. I think that is I think that's shocking. I think it's wrong. I think it is. I think it, frankly, treats victims of sexual assault as less equal, whether it's because they are women or when the issue is men. I'm not exactly sure why. But we don't treat any body of evidence like we do sexual assault kits. When a gun is recovered, we test it for operability. When drugs are recovered, we test it to determine whether they're controlled substances. But for some reason, in cases of sexual assault, this country couldn't get it together to actually test the kits from those cases where victims of sexual assault had cooperated. I think it's shocking, and I felt that we had an obligation to try to do something about it, and we have. Of the 56,000 kits which are going to be tested with our dollars, about 5,000 to date, about 5,000 kits have been examined and yielded DNA profiles. Those have been uploaded to the National Data Bank. Of that 5,000, 50% have hit. That means in 1 out of 2 kits that we've tested, the DNA profile from that rape kit matches someone who's a known criminal offender in the United States. And of that 50% of that are folks who've committed prior sexual assaults. So why? Because it cried out for someone to do something about it. Why others had a hard time dealing with this at the local level? You know, there's probably money, and in some jurisdictions, probably, it may be a prostituted woman or man had been raped, and they just perhaps didn't think that that was a case that they'd ever bring or worthy to examine, and I disagree.
Do you have any idea of the overall scope of need in that regard? You gave $38 million. What is the?
Well, I believe that the 56,000 tests, rape kits, is that number came as a result of a nationwide request for proposals that we issued. And so we tried to capture the waterfront. And the federal government, by the way, Joe Biden, who great partner,
was there at the announcement,
was there with us, and they contributed federal dollars. There are certainly more than 55,000 kits in the country. Whether it's 75,000 or 100,000, I don't know. But we have tried to cover the waterfront, and my hope is that this is such a positive step. There's no downside to this, and I'm hoping that jurisdictions around the country, when they see the power of actually solving cases by providing funds to citizens and visitors who are assaulted in their jurisdictions, they're going to make that commitment. You know, when you ignore evidence like this, you say two things, and they're both bad. You say to the victim, what happened to you doesn't matter. And you say to the perpetrator, what you did doesn't matter. And those are two wrong messages, and I felt so powerfully that this was something our office needed to step up and take a stand on, that we committed these dollars to states outside of New York.
Great conversation. I wish we had more time, but we don't. Thank you for joining us.
Paul, nice to see you again.
The primary elections will be held on Tuesday, September 12th, and the general election is Tuesday, November 7th. For more information about voting, locating your polling site, and the candidates, you can visit the League of Women Voters website at lwvnyc.org. Thank you for watching Race to Represent on Manhattan Neighborhood Network. Goodbye.